For the millions of viewers on YouTube who are watching us, we're waiting for everybody to come back to our meeting. Okay, looks like we have just about everybody. So we'll be back in session. And while we're on the break, we decided that we would swap John Day, who has been very, very gracious to give us his time, even though he is not a Texan. He, after hearing this morning's conversation, he says he'd like to be. So maybe someday we'll admit you into the fraternity, John. John is with the law offices of John Day. He's a native of Wisconsin, went to law school in North Carolina, University of North Carolina, where he was a member of the Law Review, graduated Order of the Coif, and has been involved with the American Colleges Project to try to determine how we're going to deal with the post-COVID world in terms of litigation, and whether or not the way we're doing it now is the wave of the future, or whether we're going to go back to the way we used to be. The college has put out some national guidelines, which the chief is well familiar with. But John, we're so thankful that you took the time to be with us today, and that went on a little longer this morning than I had anticipated, but it was a great conversation and useful for us. So we appreciate your waiting us out. And now the floor is yours. Thank you.
Thank you, Chip. I appreciate the opportunity to be here to talk about this important topic. The college realized in March that it would be appropriate and necessary, in fact, for it to act to help give guidance to judges and lawyers across the country on how to deal with the issues and the impact of on the justice system of COVID-19. So the current president, Doug Young, and Rodney Acker, who's now the president, he became president in September. Rodney's from Dallas. I'm sure most of you know him. Elected a group of people to serve in a task force to develop some guidance to judges and lawyers on these issues. They asked me to chair it. There were 14 other people who served. 3 of them were judges. Judge Barbara Lynn, Chief Judge of the Northern District of Texas, served, as did 2 appellate judges from Canada, but lawyers and judges from around the country got together, and in the course of 2 months, put together 5 different papers to give guidance to judges and lawyers. We did not call those papers best practices because, quite frankly, we didn't think we had enough empirical evidence to say that anything was a best practice. Instead, we used the collective experience of the group, which I'm sure approached 500 years of what would work. We did a lot of interviews, we read a lot of articles, and we put together the papers. You've got a link to those papers. The first 5 concerned remote video depositions, remote hearings, appellate arguments using remote video, non-jury trials, and effective use of Zoom technology. We then struggled with the hard work because civil trials is a much more complicated problem, and mainly because we not only have all the issues that we have with non-jury trials, but we have the problem with the physical plant, that is the courtrooms, and how do we manage social distancing in those environments, particularly when many jurisdictions don't have the money to build into the courtrooms the social distancing type devices. For instance, there's a courtroom rather in Columbus, Ohio, that put plexiglass all throughout the courtroom between all the jurors. They spent over $300,000 on 4 courtrooms. We have courtrooms in Tennessee that are not handicap accessible. There is no way that our judicial system could afford to spend the money to make our courtrooms operate in a socially distanced environment. So we instead put out guidelines on how to conduct jury trials, basically by raising all of the issues that would need to be addressed to have a plan that was reasonably safe for everybody who was participating. Criminal trials are, of course, another matter because of the constitutional issues raised, and we didn't even attempt to go down that road. Instead, we had issued a paper that discussed in great detail the constitutional issues that were raised by having criminal trials and throughout the whole criminal procedure generally, in fact. So that paper is also available on our website. We then struggled with what does the American College believe in when it comes to conducting jury trials? We support it, obviously, but what do we really believe in? And we came down with a group of overriding principles, we called them, adopted by the board in September of 2020, that basically says we believe that the best trial, the way trials should be conducted, civil and criminal, are everybody being in the same room at the same time and conducted them in the historic fashion. That is the goal of the American College of Trial Lawyers. That being said, we recognize that during periods of health crisis, we may have to do things differently. And then we set forth some additional principles that address those issues. Those papers are in the process of being updated right now to reflect what has happened since the dates they were issued in early June, August, and September of 2020 with what we've learned in the meantime, because we've got the benefit now of having lots of activity across the country by the various states experimenting with different ways to administer justice during this time. So Texas has been a leader in that. So is Michigan, so is Washington, so is Maricopa County, Arizona. I mean, it's amazing what has been done across the country to try to allow justice to be served despite limitations that none of us anticipated before February 15th. It's incredible. Texas, as I said, has been just outstanding leader in this area. You've had, as the Chief Justice indicated a little while ago, close to 100 jury trials, some of them totally virtual. In comparison, in Tennessee, we have not had 10. My office had a jury trial 5 weeks ago that lasted 3 days. That was the first jury trial in the particular county. There have been no criminal jury trials in this state, to my knowledge. So we have a mess. We have done a good job here, and so is Texas with remote hearings. Y'all are running about 100,000 per month. That's outstanding. We too in Tennessee have adopted that, and most places around the country are doing a pretty good job with hearings and non-jury matters. But the challenge, of course, for all of us is jury trials. So we know in Texas that there are 9,700 jury trials in the average year. So far, since the middle of March or so, there's been 100. That means that by the end of this year, you'll be over 7,000 jury trials behind. And I say that not in a way to be critical. As I said, I've spent a whole lot of time in the last 8 months looking at what the judicial branch has done across the country and in Canada to try to address this problem. You've done far better than most places, but here's the problem. You've still got 7,000 cases in the pipeline that that are going to need to be addressed. And I fear, just like you do, that the problem isn't going to be solved by the end of the year. That is, if this vaccine or these vaccines happen to work, and if they can be administered to people in a timely fashion, we are still going to have a severe backlog as of April 1. My guess is by April 1, Texas will be 10,000 trials behind, if not more. I don't see any way around that, and I think that's going to continue to increase depending on the acceptance level of the vaccine and how effectively it works. I don't see, quite frankly, a return to normal until the late summer, maybe September 1 of 2021. And then we will have 12, 14, 15,000 cases in the pipeline in Texas, jury trials that we're behind on. It's going to put tremendous pressure on the system. And if I don't pretend to know anything about Texas politics, but I know a little bit about politics in Tennessee, and I can tell you that the legislature isn't going to be allocating a whole lot more money to the Tennessee judiciary. And hopefully you are all more persuasive than we are here, but we're going to have to figure out a way to deal with that. It's going to be a particular problem in the criminal area because probably 50 or 60% of those trials, maybe a few more in Texas, are going to be criminal cases. And even if we had the capacity to put that many people in courtrooms, we have the same problem that the healthcare delivery system has. That is, even if we've got the courtrooms, even if we've got the hospital beds, we've got to have people work on the patients. We've got to have DAs who can try cases. And there are only so many DAs, and they only have so much capacity to try this backlog of 5, 6, 7, 8,000 criminal cases. They can only be expected to do so much. So I fear that there's going to be a heck of an impact, not just in the last 8 months we've experienced, and not just in the next 8 months, but for several years as we try to figure out how to manage this. On the civil side too, the number of jury trials are less, of course, but the way many courts assign cases, you're going to see a backlog there that's going to impact even the discovery of other cases. Let me give you an example. I've got cases set for trial now in October and November of 2021. In a couple of weeks, I'll be with a judge who's going to ask me to set a case for trial in March of 2022. But when you start having to fill up your calendar that far in advance, it impacts your availability for depositions, which impacts the discovery process, et cetera, et cetera, et cetera. So I don't mean to be a bearer of bad news. I'm sure the Chief Justice has spent a whole lot of time worrying about this very thing. But we are going to be struggling with this issue for several years to come. Chip asked me to speak a little bit about what I foresee the future to be. And once again, I don't pretend to have any particular expertise on this, except I've spent a lot of time in the last 8 months studying it and looking at the experience of people all over the country. I see the following issues, and let me make it clear. This is John Day, individual trial lawyer from Nashville, Tennessee speaking. I'm not speaking on behalf of the college when I make these next remarks. I think remote video hearings are here to stay. I was talking with a trial judge recently who told me he's never going back. He likes the convenience. He likes the fact that clients are saving money on motion days rather than having lawyers sitting around waiting for their case to be heard, to go ahead and schedule those hearings to start at a date and time certain. I know The only frustration I hear from trial judges concerning video hearings are the occasional technology glitches, number one, and number two, they say they miss seeing the lawyers. And of course, the lawyers miss seeing the judges personally too, but I think efficiency is going to sort of rule the day there many, many places. Now that we've spent the money on the technology, my guess is the technology is going to continue to be used. I expect continued remote video oral arguments in the appellate courts, particularly in the intermediate courts. I think the Supreme Courts, many of them will go back to in-person hearings when it's safe to do so, but in Tennessee, our intermediate judges love it. They don't have to travel. Tennessee, like Texas, is a big state. It's 9 hours by car from one end of our state to the other. Our appellate judges, excuse me, spend a lot of time on the road to go to oral arguments. They don't like it. My guess is that's going to continue in the future. And there's some public benefit to that, quite frankly. The Supreme Court of Texas recently had oral arguments in Burkle and Company versus Lee. There were 536 people who have watched at least part of that oral argument. The Texas Supreme Court room doesn't hold that many people. We are providing for some more transparency to the judicial system, and I think we're going to see that people like that, and that practice will continue. I think we're going to continue to see, even when this is over, an increased use of video depositions from an efficiency standpoint in money. There's going to be some rule changes that I think to make those move more smoothly, to reduce squabbling about the terms of how those depositions should be conducted. Your rules, 191 or 199, I mean, .1, appear to permit depositions by non-stenographic means, including video, and I assume that means video as well. But to the extent that anybody is arguing about that, my guess is that y'all will find a way to fix that because lawyers are going to want it. I think non-jury trials, we're going to see continued use of remote video, maybe not full trials, but more and more witnesses, particularly expert witnesses, appearing by remote video. It will reduce the cost to the litigants. Same thing with out-of-state witnesses. Now that we've got the technology in place in many of the courtrooms of the country, I think it will be used. I see with civil jury trials, there's going to be tremendous pressure to modify the way we're doing jury trials. For instance, more use of jury questionnaires to reduce the time of the jury selection process. I can see many states are doing this now, remote jury selection. That is, they have the trial in person, but they do jury selection, or at least a portion of it, via remote video. They're doing this in King County, which is Seattle, in Washington right now. They've also done it in Southern California to solve the problem, by the way, of people not having access to technology. They're supplying computers to people in hotspots so they can participate in the jury selection process from their home. Fascinating way to give people access. I can see a situation where you have trial judges specialized, take month turn, where they're doing jury selection and letting a different judge try the case. That is, having one judge work for a month, getting him or her more used to the technology, facilitating the selection of juries for a case that will start in a live courtroom several days later. I think there's going to be increased cooperation with libraries and other public places where people can come to participate in the judicial process, get access to the internet and a space free from distractions. And we're seeing some of that now. My guess is that will increase. My guess is too that you're going to see increased case management in civil and criminal cases. The criminal backlog is going to be significant, as I mentioned before, and you're going to see, I believe, an effort to reduce the number of continuances. The fact of the matter is that Judgment Day, whether it's with a small j or a big J, causes people to think deeply. And the Judgment Day, the small j version of it is a trial date. And having a solid trial date increases the likelihood of plea bargains, increases the likelihood of settlements. And I think judges are going to work even harder to try to figure out a way to give people sure trial dates to help clear the docket. And that's going to require increased case management techniques. I think on the criminal side, there's going to be a continued reliance on remote video for pre-trial matters. There's going to be still a lot of caution about conducting any sort of criminal trial, with concerns about the confrontation clause and the effective assistance of counsel issues. But there's going to be test cases going up on that, both to the state Supreme Courts under the state Constitution and the federal courts under the United States Constitution. But there are going to be people pushing the envelope on that. There's also going to be people who waive their rights to personally confront witnesses, for example, and participate in a video trial. And then there'll be questions about the authenticity and enforceability of that waiver. So it's going to take several years for those kind of issues to make their way to the United States Supreme Court. I think court reporting is going to change. I think as people get more and more used to video and all proceedings being videoed, you're going to see increased reluctance of people to order transcripts. Instead, getting transcripts only in the event of appeal or if it's necessary for a particular legal issue in the case. Same thing is true with depositions. As technology improves, I think there's going to be more and more pressure on court reporters and not as much need for their services. If people can download the audio file from a video and have it automatically transcribed with a high degree of accuracy. And then, and this is, I think, a major change that is just getting started in some places, but there'll be a lot of pressure there's going to be a whole movement to change court from a place to a service. And by that, I mean, traditionally people go to court to get justice administered. I think justice will be administered in an online way with increasing frequency. Michigan has aggressively gone into this area for small claims and landlord-tenant issues. Washington is doing the same. Other places are experimenting with it, where people basically have online access to either judges, that is trials, or mediators to help resolve disputes between themselves and don't have to physically go to the courthouse for justice. That is very controversial, but I think the increased use of video will increase its acceptance, and budgetary pressures will cause all of us to think long and hard about whether we need people to come to court, particularly on minor matters, for justice to be truly administered, or if we can do it in some other way that will achieve the same purpose. So my thoughts on where we're going, as I said, I'm not speaking for the college when I say that, but I think the justice system is going to look a whole lot different in 5 years than it did 8 months ago. I'd be happy to answer any questions if there are any.
Thank you, John. Chief Justice Hecht is the president of the Conference of Chief Justices. And Chief, I wonder if you have any thoughts or reactions to what John has had to say to us in his very thoughtful presentation.
Yeah, well, I think for one thing, he's spot on about the challenges we face, and it's true across the country. The National Center for State Courts, which helps support state courts generally, and has been very active during the pandemic, has one of its groups to deal with jury trials and studying how to do it, and all of the pointers that we can give. In Texas, I think people remember this, but just brief overview. The Supreme Court said back in March, no jury trials, period. And then after a couple of months, in consultation with the Office of Court Administration and the state health officials, we said, okay, you can have them, but you've got to get OCA's approval. And OCA came up with a bunch of guidelines, very detailed guidelines. And the reason that you need all these guidelines is because we've got 3,000 judges, and they're not used to worrying about who the local health officials are, or how you're going to get in the door and not infect everybody, and just, what are you going to do about cleaning the bathrooms, and all of the issues that you have when you start congregating people in buildings. So they put together all of those, and they approved every trial request that they got. And there were 79 of them through the end of August. And then there were a few more in September, several in Harris County, and a few in October. And then the Supreme Court just said to the judges, okay, now you have the guidelines. You don't need approval anymore. You need the approval of your local administrative judge, which you may know is in a particular county is the judge who just administrates among the several judges that are there, and the regional presiding judge, who, like Judge Estevez, who's administrative judge for a whole region. She's in the Panhandle, and that's worked pretty well. But then with the spikes in November and the unfortunate trial in the Eastern District of Texas in Sherman a couple of weeks ago, where 15 people got sick in the middle of a 6 day of a 2-week patent trial. I think everybody has just decided to shut down for the holidays and try it again after the first of the year. But it is and John's exactly right about the numbers. They're just growing. And judges, the one additional wrinkle is judges are trying to find some other way to recreate Judgment Day. And it's not easy. And everybody who's been in litigation knows that you really need that threat to get everybody to think hard about what they want to do. So that's kind of where we are. And it's some states where the pandemic has not hit so hard. We're trying cases more regularly. I know Idaho was for a while, but then Idaho spiked out again. And some states have just not, they're just hoping that the vaccine or a rapid, reliable test will make it possible to get back in the courthouse. We have tried a few criminal cases in Texas. How many? I'm guessing maybe 20 out of the 100 that we've tried, maybe a few more than that. Misdemeanors are not hard to try. Felonies are they're much more difficult. And we've tried a number of different kinds of civil cases, but the input, the resources and the planning that have to go into scheduling a 2-day motor vehicle accident case are just so overwhelming that it's very difficult for judges and their staff to do it, even though they're trying very hard to do it. And then on virtual trials, I think one big change going forward is you're entitled to a jury trial in a misdemeanor case, like a traffic case in Texas. But we've had several virtual trials in those cases, and they seem to work pretty well. And the confrontation issues, they're there, but they're just not as heavy as they would be in a bigger case. And so I think I've said before that may be a big change going forward, because last year, 30% of our jury trials were in those cases. So we're talking about close to 3,000 jury trials that we might be able to do virtually. And while those obviously are not big cases, it may take some pressure off the jury system going forward. But other than that, I think John's given us a great lay of the land.
Great, thanks, Chief. Does anybody have any questions of John before we let him go and get back to business? I will note that it takes longer, I think, to go from one end of Texas to the other than 9 hours, but like Tennessee, we both have 2 time zones, and that to me is the definition of a big state. So, any questions? I see no electronic hands raised. So, John, thank you so much. You're welcome to stay and listen for the rest of our session, but we can't thank you enough for taking the time out to join us today. Thank you.
Glad to do it, Chip. Thanks for having me. Y'all take
All right.
care. Merry Christmas, everyone.
You bet. Thanks. All right. Now we're going to have.
Hey, can I say something? It wasn't a question for him, so I didn't raise my hand. But I don't think that Chief Justice Hecht is getting enough credit for what he's done in the state of Texas. I actually tried 3 jury trials under the remote, not the remote, but with the COVID restrictions. And we're going to do our full civil remote jury trial from beginning to end in January because of where we really believe the vaccine's going to take us. And I don't want to be the naysayer, but I think we're going to be closer to 2022 before we can go back to in-person, especially in Amarillo. You know, we have one of the highest spikes. I think we're only second as to El Paso right now. So it'll be a long time before we can do any type of jury proceeding in person, even with the COVID precautions. So you guys, you don't understand. I don't think you can comprehend the leadership we've had in the state of Texas. Those trials that have gone, we had maybe 20 that were supposed to go between November and December, but we only had to cancel because our COVID numbers are so high. But if ours could have stayed stable, we would have some huge numbers, at least in our area and in the whole Panhandle. I had a lot of requests to go forward. They just had to cancel because of our COVID numbers. So I just want to say thank you. And I want to make sure that whoever's watching on YouTube recognizes what an amazing job you've done. And OCA, David Slayton and their whole team. It's an honor to be part of the judiciary in the state of Texas.
Thanks, Judge. And let me add, Chip, that the regional presiding judges who are pretty much a quiet little bunch up until now and have really stepped up, and they have really become leaders in helping the local courts get through this. And I just got an email from Judge Underwood a few minutes ago. Olin's had the virus the last several weeks, and he's well, so that's good news. That's
great. Well, you've deflected the well-deserved praise nicely, but I certainly know, and I'm sure everybody on this committee, if we took a vote, it would be one of our few unanimous votes that you are to be honored and commended for all the hard work you've done. We all know it. We all know it, and some of us know it better than others. But the state's darn lucky to have you. So you can quit blushing now and go off camera if you have to. All right. Next on our agenda, we're going to hear from Jerry Bullard. We heard from Jerry 2 years ago, as you may recall. He is with Adams, Lynch, and Lofton. He is the chair of the State Bar of Texas Appellate section. He is board certified. He's co-chair of the Legislative Liaison Committee for the State Bar Appellate section. He's got a paper that he's prepared called Hurtling Toward the Ledge, a preview of the 87th legislature. He is a University of Texas Law School graduate, Baylor University undergraduate cum laude. Jerry prepares a detailed report, ongoing report regarding the progress of bills in the legislature that affect the justice system. The way I got onto his very informative work was through a BOTA, which he contributes to. But you'll see in your materials that if you want to sign up for his ongoing reports, you can do so, I think at no charge, but even if he did charge, it would be worth the price of admission. So Jerry, the floor is yours.
Well, Mr. Chairman and members of the committee, thank you for inviting me once again to provide a little bit of a sneak preview of bills heading our way next session. As we try to still get our bearings from the pandemic and election issues and things along those lines, it's hard to believe really that the regular session is just under 40 days away from getting started. And as Chief Justice Heck referred to earlier and mentioned, we really don't know what the session is going to look like. And of course, they only have 140 days to do their work during a regular session. So it's going to be quite interesting to see what happens, obviously. And we're all wondering what that's going to look like. But I will say, and this is in the materials that I provided, and like a good appellate lawyer these days, I've bookmarked my materials, so you can kind of click on your bookmarks and follow along. It's only 11 pages, so the bookmarks may not be all that helpful, but in any event, you can click through as I talk about some of these bills. But the first thing I wanted to really bring up was on page 1, where it talks about what the pre-filing stats are looking like. November 9th through the 30th, there were over 887 bills. Well, there were 887 bills and resolutions filed, which is ahead of the pace of the past few sessions. I've kind of given you all a timeline going back to 2011 to let you know kind of what the pre-filing session period looked like in November. So we're way ahead of that pace. There's typically anywhere between 5,000, 6,000, 7,000 bills filed each session. So there's a whole lot more that's going to be coming down the pike that we'll be taking a look at, and I'll be monitoring the best I can. Through yesterday, that bill and resolution total was up to 950. As you might expect, there are several common threads in a lot of the bills that are filed. For example, there's over 80 bills filed dealing with election issues, whether it be registration, voting processes, things along those lines. There are lots of those bills that have already been filed. There's over 6, I think, that's really seemed to me to be pandemic specific. I'll talk a little bit about those later on. And then there's several what I'm calling the separation of powers type of legislation. Obviously, with some of the controversy that's going on about what the governor can and can't do and what the courts can and can't do, and under an emergency declaration situation, there's about 8 to 10 of those that are out there right now, but there are going to be more. And so, we're curious to know if those sorts of issues, in addition to budget issues, are going to take up what we like to talk about as being all the oxygen in the room. to where some of these other issues dealing with civil justice, things that are important to us, we're not exactly sure where those are going to fall in terms of the priority list that the legislature may have. You know, one thing I typically like to do as we head into each session is kind of look at the legislative demographics. This is not in your materials. I kind of started taking a look at this over the last couple of days. So it's the statistical analysis that I'm going to throw out to you is just totally my own. So it's unscientific, but I think it's pretty close to what it's going to look like. You know, the breakdown in the House from a political standpoint really is going to be unchanged this session. 83 Republicans, 67 Democrats. With the changes that did occur, you know, those numbers didn't shift at all. On the Senate side, there was only one political shift. We lost one Republican member that moved over to the Democratic side, which is significant in this regard. Currently, under Senate rules, there's got to be it only takes 19. You have to have 19 senators to bring a bill up for debate. It's a 60% rule. And so, you know, right now, if there's only 18 Republican type of bills, that may be a little harder to get to the Senate floor for a debate unless there's a rule change. And so there's a question whether or not those rules are going to change once the legislature convenes. Of course, there's still an outstanding Senate race. Will be a runoff later this month up in my neck of the woods, but those are two Republican candidates. So that's not going to change the 18-13 split. It may affect the numbers in the House just slightly because Representative Springer is in that runoff for that Senate seat. So if he moves over to the Senate, then that'll create a vacancy in the House. But on the House side, if I'm doing these numbers right, I'm checking the Secretary of State numbers, there are 17 new House members. And that breakdown is 6 Democrat, 11 Republicans. On the Senate side, there's three new members, 2 Democrats and one Republican. So, you know, it's nice to know those dynamics, so you kind of know what the lay of the land looks like there. Another demographic I like to take a look at is how many licensed attorneys do we have in the legislature? If I'm reading the numbers right and I'm checking the backgrounds correctly, there are 53 in the House and 10 in the Senate. And so then those are not necessarily practicing lawyers. They have law degrees, according to the state bar, but they may not have active practices. So, which usually, you know, is interesting to me because that way, if I have to bring up an issue to a legislator or anybody who receives my updates and they want to get involved, that gives them a good idea who they can talk to. So, you know, that's the demographic lay of the land that we're dealing with when we start talking about some of these bills. My paper really, like I said, highlights some of those I think that are of interest to most civil trial and appellate practitioners. I won't go into too much detail because they're in the materials, but here are a few of the notable ones, at least that jumped out at me. On page 2, under damages, there was a bill introduced by Senator Charles Swertner, Don Buckingham, and Donna Campbell, Senate Bill 207, dealing with the recovery of medical or healthcare expenses in civil actions. One friend of mine referred to that bill as paid and incurred on steroids. There's 5 different options there essentially for determining what sort of evidence will be allowed when you're talking about recovery of healthcare expenses. So Senator Swertner had filed a slimmed down version of that bill last session. Didn't have quite as many options, but it didn't get very far. Now we have Senators Buckingham and Campbell joining him, all physicians, who are going to be carrying the water on this particular bill. So it'll be interesting to see how that one moves through the process. On page 3, under insurance, we're calling it the Brainerd bill. Representative Guerin from Fort Worth has filed HB 359 to deal and basically codify the Brainerd situation under when you're entitled to seek, you know, recovery under a UIM or coverage type of situation. Representative Guerin's bill made it a little bit further down the pike last session than others did. It didn't pass, so it's coming back again. One of what was of particular interest to me is under the judiciary category, and it's HB 339, composition of the Court of Appeals districts. I've been told from a couple of sources that that's a placeholder bill, with the idea being that there could be a larger redistricting of the Court of Appeals proposal that will be coming down the pike later on in the process. This particular bill really only focuses on overlapping jurisdictions in the 5th, and the 6th and 12th courts of appeals. But there are bigger plans for that particular bill. So that's something I think we're all going to be, at least from an appellate standpoint, and I think all of our trial lawyers are going to be wanting to see what that looks like too. But there's going to be a move or an attempt to redistrict the courts of appeals to some degree this session. What that plan looks like, I've not talked to anybody who really knows what that ultimately might look like. Got some theories just from following this stuff for a while, but I really have nothing to hang my hat on. But that'll be something we're going to want to pay attention to from a practitioner standpoint. I added the separation of powers bill on pages 5 and 6, dealing with the executive power following a disaster emergency declaration, HJR 15. There's a House Bill 173 that goes along with that bill. Representative Springer filed those bills. So we're going to see lots of bills like that, I think, to deal with these separation of powers issues. Now, those are bills that are currently have been filed. So, we know those are going to be addressed at some level, to some degree, as we move along. Possible bills or anticipated bills on page 6, that's where I start listing some of those that I think we're going to be seeing again, primarily because we've seen them in the past. One of the most popular questions asked to me is, are we going to fix CPRC 38.001 about recovering attorney's fees in civil cases? There have been numerous attempts to file bills to deal with that issue, to make attorney's fees recoverable from all sorts of business organizations and not just corporations or individuals. All those attempts have failed for various reasons since 2014, I think. That's when the case law started coming down, interpreting 38.001 in the way that it has been to cause this bill to be filed. But all those efforts thus far to amend that statute have failed. Attorney access to courthouses. That bill didn't get very far last session, but it's my understanding there may be another attempt at that. I don't know what that's going to look like, but we may see a bill along those lines too. Pages 7 through 8, the judiciary related bills. David Beck has already talked about the judicial selection effort. So I put in this paper like a description of what the last bill looked like, which was the one that he was referring to that Representative Landgraf had filed, just so you can get an idea of what that bill looked like before. I also have in there the creation of a business court and court of business appeals bill. We've had a couple of attempts to create chancery courts or business courts in the past. Not exactly sure if this is one of those bills that might fall by the wayside this time, just because of the other issues. I know there are several groups that are still interested in creating a business court system. So we'll see if something gets filed along those lines. If it does, it may not get very far, but we shall see. On page 10, just some generic topics, primarily dealing with COVID. There have been 4 bills filed already dealing with workers' comp coverage and creating presumptions of coverage for certain classifications of employees, like public employees, first responders, nurses, etc. I've been told by several folks that we're probably going to see some sort of limitation of liability type of legislation filed for COVID-related situations. There are already 14 states and the District of Columbia that have filed bills to limit liability of businesses and manufacturers and folks who manufacture PPE and things along those lines. So we're probably going to see some bills dealing with the pandemic. So those will be ones we'll be keeping an eye on. I have a section in pages 10 through 11 dealing with judicial council resolutions. Justice Hecht already kind of talked about that earlier, about some of those initiatives. So I won't cover that ground again. But primarily that's all that I have in terms of what's in my written materials. And Mr. Chairman, like you referred to earlier, I've been doing these updates and since 2004, I think. Some may question my sanity, but I really do enjoy doing that, keeping track of legislation that goes through the process. It is a public service for me, so there's no charge. But it's also a way to keep my colleagues informed, judges informed. There are legislative staffers who receive these emails because they keep track of everything either. So it is a public service. I enjoy doing it. But I'm happy to add anyone else to that list if they want to be added. And that's really all that I have. So I'm proud that I can keep it short and sweet to the point. But if anyone has any questions, I'm sure happy to try and field them.
Great, Jerry, thank you so much. And if anybody has questions, you can. We've become pretty adept at getting to our electronic hands on this committee. It took a little while, and on the Commission on Judicial Selection, I'm not sure we have mastered that task yet. But so, any questions for Jerry? All right, I see no hands raised. So you got off easy on this one, Jerry. But thank you again for wading through all that came before and for giving us a very informative presentation. Thank you.
Well, you're welcome. I'm happy to do it.
Great. All right. We will turn to our next agenda item, which is Nina Cortell and Evan Young on whether the Supreme Court ought to adopt a procedure for granting or denying review based on the petition for review. So Nina, I don't know if you are starting or Evan is, or whether you're both in the same room and you're going to do a duet.
Thank you, Chip. I'll go ahead and get us started. Chip invited us to suggest topics for discussion. This is just a topic, frankly, that I've been thinking about for quite a while. It's been my great privilege to appear many times in the Texas Supreme Court. And while I appreciate the reasons underpinning the current procedure, I thought perhaps after almost 25 years of using it, it might be time to revisit and see whether we might not adopt a procedure a little bit more along the lines of the United States Supreme Court. So by way of background, for those that may not do this quite as often, the current, I'm going to just generalize, the current procedure in the Texas Supreme Court to get review is essentially a three-stage procedure. There's the first stage, which is the petition for review. And at the conclusion of a petition, and if requested, a response and then a reply, the court decides whether to ask for full briefing. It takes 3 votes to get to full briefing. So if you're lucky enough to get that request, then you go into a briefing schedule. You provide much longer briefing than you did at the petition stage. And at the conclusion of the briefing stage, the court decides whether or not to grant review. The decision can be decided per curiam, or you can be allowed the opportunity for oral argument. So it's really a 3-stage procedure. And what that means is that you can go through the first 2 stages and not get review, which means you've not only filed a petition and then gone through that, but also full briefing. That is different from what you have in the United States Supreme Court, where the decision to grant review is based on the initial petition and related filings, and you only file your brief on the merits if review is actually granted. Currently, I think the statistics, and I defer to Pam Barron and other experts who monitor that, but I think the current statistics on cases that go to full briefing now in the Texas Supreme Court as to whether you really get a grant or not is approximately 40 to 50% of the time. So at least half of the time that you file complete briefing, you've gone through the expense and delay related to that, you will not get review. And that has several implications in terms of cost and delay, but also it goes to the type of briefing that gets filed, because in the current proceedings, the way the procedure works now, your brief on the merits, since you haven't gotten the agreement for review yet, you're still arguing for review or against review, depending which side you're on. And you're not really at liberty to devote 100% of your energy to the actual substantive issues. And sometimes that can carry with it consequences where the merits perhaps are not dealt with as fully as they otherwise would be. Now, to put this into context, the original procedure before 1997 was we just had full briefs on the merits, and then the decision was made whether to grant or not. And it was a very good change in 1997 to go to the current proceeding because it allowed you this earlier opportunity just to file a petition, explain why review is necessary. And I even remember, I'm sure Justice Heck does as well, sort of the roadshow, I'll call it, that the judges went on to sell the new procedure and promised us, and I think held to that promise, that they would read this shorter filing, that we would get actual review by the court. And I think the court has held good to that promise, and I think that has worked well. I in no way have any concerns about that. That said, having looked at it now again for almost 25 years, having had the, again, honor to be going through this procedure quite a lot in the last few years, I thought it might be worth a conversation at least as to whether to revisit our protocol. In getting ready for today, I did talk with Evan Young, who had studied this with others a few years ago and prepared a memo at the court's request, Martha Newton and Jackie, and I'll let each of them add their thoughts, if that's okay, Chip, before we go to open discussion. But I will want to note that several years ago, Martha and others undertook a survey, and at least it appears that we are likely the only state in the country with this sort of three-part procedure. Now, a lot of states are very distinguishable from ours, but even if you took 25 of those and you said none of them are doing the way we do it, so maybe it's time to give it a thought. So I'd like to turn it over to Evan, if that's okay, as well as Martha and Jackie.
Yeah, of course. Evan.
Thank you. I will keep mine brief and want to maybe ask some of the same questions that Nina has asked in a slightly different way. And that is, if we're having our big thoughts meeting, the big question might be, what is a petition for review? And what is a brief on the merits for? And right now, under our current system, I don't think that we can really say that a petition for review is a petition for review. It's a petition for review, which means that a brief on the merits isn't a brief on the merits because it is functionally the petition for review. And Nina got at that point a little bit, but when you file the very short petition for review, the way that it actually works is that you're just trying to get enough votes so that you will file that longer brief on the merits. But precisely because you have no promise at that point as the petitioner that your case will be heard on the merits, and no certainty as a respondent that your win will be even considered by the court on the merits, both sides, when drafting what has that label on it as a merits brief, end up, I think, whether subconsciously or sometimes consciously, focusing largely on still persuading the court either to take the case and perhaps setting aside complications that might make the case less desirable, even if they really get to the merits, or to not take the case and perhaps subconsciously or consciously set aside some things that might be helpful to you on the merits, but might make the case seem spicy if you're a respondent and you don't want the court to take it. And so that, I think, leads to a series of problems that really have effects for all the participants in the system, ranging from the clients all the way up to the justices and their staffs. And some of those, we can discuss that with this whole group. There are a large number of people on this call that I think are participants in this process and have great insight in it. But some of them that I think are serious relate to the incentive structure, ranging from the willingness to file a petition in the first place to whether a client or a lawyer is inclined or able to spend the energy to prepare a proper brief on the merits, given the incentives that currently exist for trying to persuade the court to take review or to deny it, rather than to actually argue the merits. And then the concomitant results such that when a merits argument is allowed and the court has taken a case and put it on its plenary docket, occasionally one might perceive that counsel discover now that suddenly their case has been plucked from that potential pile of one-line denials after having gone through all of that, well, there's maybe more to this than we thought. Maybe a respondent's counsel realizes there are certain things we really would like the court to know now that we actually have to defend our win below that we didn't really want to say at that point. Or frankly, the client said, well, I'll be willing to finance some of this, but I'm not going to really pay what you think is necessary for complete, thorough briefs on the merits when you tell me I have maybe a 60% chance of this ending in nothing. And now we're going to be arguing before the Supreme Court. So client, you really need me to do this. Or the lawyer saying, well, I'm going to have to do it for my own reputation, whether the client really wants me to or not. And all of those are collateral to some extent. But the central problem is that I think they exist in some number of cases such that the cases evolve in ways that would be less problematic if before a brief on the merits were presented to the Supreme Court of our state, people knew, as with, I think, every other state Supreme Court and the Supreme Court of the United States, that it really is a brief on the merits. And this is our chance to make the statement that we want the court to understand will be a merits argument and not a plaintive cry for review or an attempt to continue to diminish the reviewability or the worthiness of review of the case. And so, whether we agree or disagree that the current process has opportunities for change, one question that should be considered is, well, what can supply something that's better? You can't really beat something with nothing, and I don't think anybody would try to do that. I guess I'd start by suggesting, well, we wouldn't really be in that position because every other state in the Supreme Court of the United States seems to be able to do the job without being entirely unsatisfied with the results, without having a petition for review that isn't really a petition for review and a brief on the merits that isn't really a brief on the merits. And so we do have some things to follow. But what we might also recognize is it's not as though this came for no reason, that there's nothing that's being served by it, or that there aren't institutional interests that would be undermined, at least temporarily, by making a change. And I think some sensitivity to all of that is also sensible and sound. So the question is, what is it that would be lost by doing this? Well, one is we have these shorter petitions that the justices can actually read. If we have a petition that leads immediately to a grant and it's as short as it is right now, then the likelihood is that at least in a number of cases, the court is going to be very concerned that it is not empowered to know for sure that it is selected wisely and that the case actually implicates the kinds of questions and doesn't have the sorts of defects that might be fleshed out in full briefing. And a solution is to say, I would suggest for the court's consideration, this group's discussion, that a longer petition that begins with a much shorter summary would achieve the goal, because a lot of petitions end up being things that can be eliminated very quickly. They're just not going to work. But if we have a longer petition, then the justices and their staff can look at the short summary, the introduction, and say, if I'm not persuaded in 1,000 words, when you're just giving me your best pitch as to why this warrants one of 70 or 80 spots on a plenary docket of a large state's highest court of review, then I don't really need to know much more. I can just deny that petition right now. On the other hand, if they're interested, if they think this really is a case that might be warranted, rather than now having a whole nother round, call for merits brief, just turn the page and it's there. And if the court is interested enough to call for a response, it calls for a response, and that response can be that longer, maybe 9,000 words instead of 4,500 words, in order to make sure that every aspect of the case, and not the merits necessarily, that's, I think, not irrelevant to the grant, but not the primary goal of a petition for review, but that every aspect of it, jurisdiction or defects in the record, whatever else, can be fleshed out. No more unbriefed issues, no more, oh, wait for briefs on the merits and then you'll see how good it is. Just give us another shot. Just here it is. Make your decision. And if it's no good, we have finality. We don't have to delay for briefs on the merits and all of that in order to determine whether the judgment below becomes final on the mandate issues. I guess the last thing I would say is that it seems to me that if we can persuade the court to consider something that that would be a modified version of what the US Supreme Court does. It would align all the incentives for everyone. Clients would not be able to file a rather short petition for review just saying, hey, let's see if it sticks. Let's see if we get to the next stage. They'd have to file a real petition for review. But on the other hand, clients who do that multiple stage would be willing to do it properly. And so would lawyers, because they know that if the petition for review is granted, that means they're in the game for the long haul and everything they say is the main event. I think that the court then would be served well by having documents that are filed that actually answer the specific questions in the petition for review. Is this a case that's worthy of being in your docket? And briefs on the merits. What is the right outcome now that you've agreed that it is on the merits? And we would have less need for big twists and changes and post-submission briefs and pre-submission briefs and late amici and all the rest of it, because all of the work that would be on that timeline would be aligned with the reasons that we want to have those filings in the court in the first place. So maybe that was a little longer than I promised, but I get carried away sometimes. And I try to restrain myself when I can, but I'll stop.
Okay, Evan, thank you. And I'm guessing you're in favor of this change.
Cautiously, tentatively in favor.
All right, Martha or Jackie, you got anything to say about this? And I don't expect some, kind of brief, like outline. We want to really go into the depth of this. Evan is, he's just never gives us enough substance. But Martha or Jackie, you got anything?
Well, as an employee of the court, I'm going to stay out of the merits of the debate, but I'll just confirm that I did look in about 5 years ago, did some research on just trying to figure out if kind of the way that we do things was the norm among other state Supreme Courts or whether we were in the minority. And so I looked at the briefing rules with the help of a paralegal of all of the state Supreme Courts or state courts of last resort with discretionary jurisdiction. And it appeared that we are the only state court of last resort with discretionary jurisdiction that routinely solicits merits briefs before making a decision to grant review. And I'll just give some caveats that I really at the time was just trying to get the sort of overall trend more than 100% accuracy. So that may not be completely accurate, but we're definitely in the minority. And then I haven't updated that research, so it may be somewhat out of dated. But so that was my involvement, and so I gave that background to Nina and Evan before the meeting today.
Okay, but you're not arguing against our uniqueness, are you?
I would never argue against Texas's uniqueness, no.
All right, Jackie, even though you're an employee of the court, you want to weigh in on this? We're scaredy cat. Martha doesn't want to.
No, I don't think I'll weigh in either, but I will say that I do think there is an appetite for this outside of Nina and Evan. Basically, every meeting I go to, I get asked about this. I'm guessing Evan's been talking behind the scenes. So I think there is appetite for a change here.
Okay, great. Thank you, Jackie. Scott Stoley. Got to unmute, Scott.
I changed that. Thank you, Chip. I want to add to the history lesson that that Nina so ably gave us. Back in 1997, when this change was made, I liked the change because the old system involved filing full briefs that were then condensed by a first-year law student working for the court, or a first-year lawyer, rather, working for the court. And I felt like it was a better thing that my case would be judged based on a petition for review that I drafted, where I did the summarizing, rather than a first-year lawyer doing that internally inside the court. So I liked the change. Since then, I agree with the sentiment to reform the process somewhat, because my experience has been that it's too expensive for clients to go through 2 rounds of briefing and then have their case denied. I've I've had some cases that I thought would be granted, they weren't. And the clients were understandably puzzled by, why did I spend all this money only to have my case denied? So I think it's too expensive right now. Also, I think it injects too much delay into the process. Busy appellate lawyers tend to ask for a lot of extensions, and I'm as guilty of that as anybody. And so when you have 2 rounds of briefing and 2 or 3 extensions each time a case, each time a brief is due, it builds in a lot of delay into the Supreme Court process. And again, clients are very puzzled and disappointed by that. So I'm in favor of some kind of reform that would make it less expensive and not take so much time. The final comment I will add is Evan mentioned that maybe we would no longer have the idea of unbriefed issues so that they would all have to be briefed in the petition stage. My initial reaction is I still like having the idea of issues that are not briefed at the petition stage. I think that it makes more sense to let the lawyers choose which issues they think will sell. And then if the court does grant review, go ahead and let them brief the issues that they initially didn't brief. So those are my comments. Thanks.
You bet. Lisa Hobbs.
So I agree with a lot of what's said. I mean, definitely we've identified problems with the current procedure. I will say that most of the comments seem to be geared towards the petitioner side and not the respondent side. And as somebody who does both, you know, sort of the really high end money deals that are likely to get the court's attention, but also a lot of cases that, you know, as a solo, I get to take a lot of cases that aren't just like the high end money stuff. I will say that and again, Pam probably could correct me on the statistics, but we're talking about 25 or 50% of the cases go away with just a response, like a response to a petition for review. And so from the respondent side, it actually can be a money saver. So like we're talking about it from the petitioner side, but sometimes like when the Court of Appeals got it right, which to all the Court of Appeals judges on this call, I think you mostly get it right. But I think there's some money saving aspects to it when I can just file a 15-page response. It's like, no, really, the Court of Appeals got this right. We're good. And that takes care of a lot of cases. So again, I'm not opposed to re-envisioning some aspect of this. I agree with a lot of what has been said about the problems with briefs on the merits when you don't know if the case is actually going to be granted, and the money that goes into that, and the strategy that would be different than if you were just briefing it completely. But I think if the court is going to study this issue, make sure you are studying it from both the winner and the loser side on the Court of Appeals. And then the other thing I would say is, as an officer of the appellate section, I would hope that the appellate section would be super involved in determining like how to best, like if we're going to change the process, that they would be involved in that. And we have lots of ways to get input for the court that we would be happy to do that for the court, to get more input from a lot of different type of practitioners and not just, you know, big case type practitioners.
Nicely said, Justice Christopher.
Well, a simple solution might be for the Supreme Court to require 5 votes before they ask for full briefing. And that's just something for them to think about, because then you'd have 5 people that were, you know, thinking that there was an important issue here instead of 3. And I think if 5 people agreed to it, the grant after full briefing would be a lot larger. And that would save a lot of money in the system. So just my thought.
Great. Thanks, Judge. Frank Gilstrap. You got to go off mute, Frank.
Here, I want to just add to the comments that Lisa made. There are not only cases that go away after the response is filed, there are cases that go away when the petition is filed. Under Rule 53.3, you can file a waiver and the court will not grant the petition without hearing your response. And so in those cases, and I think there are a significant number of cases, the respondent is out no money for preparing a response, and the petitioner is not out any money for preparing a reply brief. There are just some cases that the Supreme Court, and this includes big important cases, that the Supreme Court is just not going to touch. And that feature seems to me to be really helpful. And if we change the feature, we don't need to get rid of that provision where the respondent can say, I'm not filing a response unless asked. Otherwise, we'll be throwing the baby out with the bath.
Thank you, Frank. Any other comments or questions from anybody? Yeah, Scott.
Yeah, one additional thought, Chip, is Evan made the comment that maybe the word count for the petition would be increased. I would just say, as someone who's been practicing a long time, I would still try to keep my petitions around the 4,500 word limit. And I think a lot of good appellate lawyers would do the same. Even if the word count was increased, I think you hurt yourself if you spend too many words in the petition when you're trying to get the court's attention. You're trying to get them to read it and understand it and decide it's worthy of review. And so even if the word count is increased, I think you will see that good appellate lawyers will do their very best not to use the extra words.
Okay, thanks, Scott. Richard Munzinger.
Stoley opened his remarks by saying he was in favor of the system originally because it made it more probable that a judge would review the application rather than a clerk. There's a lot to be said for that. A lot to be said for that. I don't want to trust a first-year law student with my client's rights unless I have to. To get behind Massachusetts and California is certainly not prudent for us to copy the processes of other states. Our system is pretty dadgum good. It works pretty good from the Supreme Court's level. It seems to me that the Supreme Court can limit its actions to cases that are important to the jurisprudence of the state. That's the purpose of it. And it is the judges themselves who are making the decision if our system is being followed as it is. If the court were to say we need 5 judges to get in to have your petition granted, I think that's they could go home after a month's work in January, probably. But the system we have, what's wrong with what we've got? Why do I want to copy Massachusetts, for God's sakes? Why do I want to copy California, for God's sakes? We've got a system that is working and working well. We ought to keep it and go about our business. Thank you.
Thank you. Marcy Greer.
Hi, can you hear me okay?
We can, but if you want us to follow Massachusetts or California, you're out of order.
No, I wasn't going to advocate for that. I will advocate for a little bit of an increase in the word limit because, as this committee probably recalls, I did a very important peer-reviewed study on how many words actually get into petitions and short briefs, and proved that good lawyers can get in more than 300 a page. So I'll renew that motion on rehearing for a little bit more. But I also think Scott raises a good point about keeping them short. I think Justice Christopher's idea is a really good one, because I am torn on between these, the two processes. I completely agree with everything that Nina and Evan said about how the brief on the merits spends a lot of time trying to convince the court to take the case. And I do think that's extremely problematic. And maybe a compromise position would be to have 4 justices vote for briefs on the merit, because it takes 4 to grant. So there's a symmetry there that could be helpful to limit the number of times that there are briefs on the merits and hopes get up and delays in the case, et cetera, only to find out that the case is not worthy. And that's a hard message to give to a client. And I don't know what the statistics are on that, but it seems like it could be fewer that would get to that level.
Great, thanks, Marcy. Skip Watson.
Thanks, Chip. Marty just said everything I wanted to say. I agree with the proposal. I remember asking then Justice Jefferson when I got my first grant under the new system, or my first request for briefs on the merits, why do I need to write more? I mean, I spent a lot of time condensing this down to what I had to say. I can throw in some more cites and stuff. Well, I did, but it was all in the first one. I think if we had another 500 or 1,000 words, that would be fine. But I think the better lawyers in the group will still try to make it as short as possible, get to the point, nail it, and then get out. And hopefully that's going to be read cover to cover as opposed to the first 3 pages. I think it's an idea that's time has come. And I also agree wholeheartedly and was going to say that we ought to go to 4 judges for a grant, 4 judges for briefs on the merits. That would be a huge, huge improvement. That's it. Thanks, Chip.
You bet. Lisa Hobbs.
Just one more comment. And I like the proposal from Justice Christopher and as endorsed by several other people after her of increasing the amount of votes it would take to get briefs on the merits. That actually would make sure that when you spend that kind of money that you spend, because it's very expensive, as Nina started off this conversation with how much money clients spend on the briefs on the merits, it is astronomically expensive. But then I also, there was something that Skip just said that it might be sort of a in-between approach without changing the system too much, is to just, when the law clerk is doing her study memo on whether the court should grant, that the rules specifically state that you don't need to state why it should be granted, but that you'll guarantee that the law clerk will go back to the petition stage and actually think about like what was the initial pitch to the court that got the court's attention about why this might be important to the jurisprudence of the state. I probably, as an advocate, might not rely fully on the law clerk going back to read it. But if it were in the rules, it might give you some way to get briefs on the merits that were true briefs on the merits and sort of let the petition or the response brief like speak for itself if the rules really showed or y'all convinced advocates that the law clerk was going back to read that and then this brief was going to be something different. Just an idea as Skip was talking.
Okay, thanks, Lisa. Pam, do you want to talk about your paper, What Are the Odds, which you just circulated to everybody?
Well, there's a lot of numbers in there. I don't have them memorized. But basically half the petitions that come into the court are DOA. They're denied at the first cut. Then, a certain percentage go to briefs on the merits. The effective grant rate, I think, at the brief on the merit stage overall is about 40%. So yeah, it is expensive at the second portion for the people who get into that box. But as Lisa said, it's cost efficient for those in the upfront who are trying their case for no good reason, usually, to bring it forward to the court, and they're denied pretty expeditiously. In terms of delay, the court is moving on these things faster than it's ever moved. So I don't know that that's a significant issue. Briefing, people do get extensions. It does take a little bit longer, but that's just part of the process. Just in terms of what Evan said, though, I definitely agree. I've never liked the petition for review process. Justice Heck may remember that I did lead an effort in 1997 that opposed it as being way too short. And the problem with having such a short document is that it becomes a sales pitch and no substance. And I think that when you are doing that, the court is sometimes snookered into going into full briefing on cases that really don't merit it because the parties don't have the ability to provide a merits briefing of some sort at that stage, but all they're doing is making the issues look big, making the issues look important, ignoring the facts, ignoring preservation, and just trying to sell. You're making a sale. You're a vacuum cleaner salesman bringing the dirt in the door with your petition for review. So it's not a great process. It is very expensive, but there are a lot of trade-offs. It's very good at culling out the ones that have no business being there, but for the other people, it's very expensive.
Thanks, Pam.
And read the paper. There are great numbers in there. It's very useful to take to your clients.
Good stuff. Thanks. So Nina or Evan, any final words on this before we close it out?
Well, I'll let Evan follow, and I know I predict he'll have something to say.
Yeah, he'll have one small little quick point.
Just one small little addition. But mainly we wanted to plant the seed for all the reasons that have come out, I think, in this very helpful discussion. So I appreciate everybody pitching in. I will say I'm not sure I understand that this is not also advantageous to the respondents, because they would still hopefully be able to get their case resolved before briefing. So I think in the wash, this is I never intended this. I'm also on both sides of the docket, and I think it would be an equal opportunity benefit for both sides. I think there have been some other interesting statements about what would the petition look like or not, and I think that could be worked out. And finally, I want to say that I understand, and this didn't quite come out in the discussion, but obviously the benefit of the 1997 change was the commitment by the judiciary, our justices on the Texas Supreme Court, to be involved at the petition stage. And I would not want to compromise that. If a change would mean that the judges aren't involved, then I think we'd have to look at that. But I'm assuming that we can have petitions written in such a way that they are still that's still a very feasible task for judges directly to review at the petition stage before deciding whether a case is worthwhile or deserving of briefing on the merits. But I appreciate everybody entertaining the topic without a big research paper to present to you on this. Again, we just wanted to put it in the queue for consideration. So now I'll turn it over to
that's fine. That's what deep thoughts are all about. Just throw it out there and let's see what we think.
Well, we appreciate the opportunity. Thank you.
Evan, you've got a whole bunch of time left.
Yes, well, let's see how much of that I can manage to use. Yes. I think that a lot of the concerns that have been articulated are valid, but would not be undermined by having a two-step rather than a three-step process, ranging from having a petition that requires the petitioner, if you really want to disturb the judgment below, to make your best case that the court can actually decide upon based upon what you say, followed by the retention of the opportunity, the expectation even that respondents will waive. First, that will probably discourage some of the current petitioners from filing. It's a comparatively simple thing right now. 4,500 words, maybe just to even impose some pressure on a respondent. Well, this is your one shot. Some people may say, I don't think I've got enough of a shot to do the longer thing when I know that it's going to happen. Or if they do, it might likely, as with the US Supreme Court too, generate an equal number of denials without a call for a response. So one thought that had even been suggested a couple of years ago was to say to respondents, look, we're not going to ask you to respond any faster, maybe even take a little longer, given that the potential for your response will be more serious. But let the court know within a week or so if you plan to waive or if you plan to respond without being asked. And it's not often a good idea to respond without being asked, but sometimes there are reasons for it and people might do it. But right now we'll wait. We'll have that long process. We might not know until the end of it whether somebody even wants to waive. If somebody wants to waive, let's do it quickly, just announce that you're going to do it, then the court can process it and get rid of all the ones that Pam was talking about that don't belong. And we've saved everyone a lot of trouble. It's for the ones that have a more seriousness to it that's the larger concern that can either cause undue expense, create the incentive disalignment that we've been talking about, and the frustrations that might come from going through a long process only to ultimately have it be taken away as though nothing had ever happened at all, a one-line non-precedential denial. And the idea that had been articulated by some to increase the number of votes to call for briefs on the merits, I think I agree with that, but the point is, don't just increase the votes to call for briefs on the merits, increase the votes to call for briefs on the merits because you've taken the case. And what's really the difference between that and calling for briefs on the merits and then having another step to decide whether to take the case, which retains the same disalignment that we have right now, where you're still trying to persuade them, hoping not to lose any of the votes, or still hoping that you can drop off one of the four that's granted it. I think that the only real difference is that you're worried about an improvident grant, because otherwise you have the 4 votes to call for briefs on the merits. If those same 4 at least will grant the case, then to have lost one means that something has happened that has caused you to think this is a bad idea after all. Well, there are solutions to that problem too. And the US Supreme Court has changed its practice in relatively recent years because it had a couple of what they call digs, dismissed as improvidently granted cases. And they don't like that any more than any other court does. But they have the full certiorari process where you lay it all out. And if there are 4 votes to grant the case and then call for briefs on the merits because we know we're putting this on the calendar, brief it because it will be argued, rather than risk a dig, they typically will wait at least a week and they'll have another review by law clerks perhaps who have not yet seen the case, just to make sure there's no jurisdictional defect, kick the tires a little bit, and then they'll announce the grant a week after that. But it's a real grant as opposed to doing all the briefs on the merits in that case, having the amici come in, spinning up the chambers, and then saying, oh my goodness, if only we had taken that extra couple of days, we would have realized nothing in this case will actually allow us to answer the question presented. And it works pretty well, and it avoids having any briefs that are filed that end up being stillborn because the case ought not to be granted. So I support the idea. Let's raise it to 4 votes for briefs on the merits. And that same 4 votes should be a vote to grant. And only if there is a real problem that develops, mootness or otherwise, should a case be taken off the calendar. But that would be a very small price to pay by comparison with having some 60% of the cases that go through all that briefing. Maybe it'd be smaller if we get it to 4 votes that end up not being granted. So for all of those reasons, I think that allowing people to have a longer petition for review, not that they should use it if they don't need it. Of course, it's always advantageous to say things as concisely and persuasively can, but to take that extra space if you do need it, so that if the justices, who I hope, to Nina's point, would agree at least to read this preliminary statement, this introduction that ought to be in the petition before you even get to the table of contents or anything. What's this case about? Is this something that even plausibly interests you? And if they say it does, they can just keep turning the page instead of having a whole new order to call for briefs on the merits. So I hope the court will take it seriously and experiment a little bit with it. We don't need to be like any other state or the United States Supreme Court, but we don't have to deny that there might be some wisdom in the fact that some 98% of the other high court jurisdictions have been able to work it through, and perhaps without abandoning everything to some law clerk to do it either. I think we can have the best of all worlds, and our Texas Supreme Court continue to provide the extraordinary service that it provides to the people of our state and the entire country when they're litigating in our state. And perhaps we'll even save them some time because they won't have to do study memos on a bunch of cases that ultimately will be subjected to a denial without any formal work at all.
Thanks, Evan. I don't see any other hands raised, so we will conclude our deep thoughts session for today. And as the chief mentioned at the beginning, it appears that the last 3 years have gone by very quickly. So that the next thing we'll hear is what the court is decided to do with reappointment or not of all of us. And when that occurs, you'll be getting a schedule for 2021. Let's hope that sometime in 2021 we can do this in person, because even though this is not a terrible substitute, I still miss you guys, even Evan. So unless anybody has anything else, we'll stand in recess.